are the biggest roadblocks that actually stop you from becoming the best litigator. So first of all, the most important mistake that we, or the biggest mistake that we make is, taking things for granted. We often presume that, this is how a particular court will behave. This is how the procedures work. This is how, of course, there are certain procedures. There are certain procedures of how things are to be filed, how things are to be presented, how things, certain ways in which, the court functions and works. Certain ways in which most of us in our legal fraternity approach when it comes to drafting, filing, presentation of cases, etc. But when I talk about taking things for granted, I mean, let us not take things for granted. When I say let us not assume that a particular judge or a particular court would behave in a particular way, and on a particular day when you're entering the court, this is the only process that is going to happen. What I always advise against the norm to become a good litigator or a best litigator is, whenever you're stepping into the court, always be aware of the case that you're going to represent, or even going to mention before the court. You must have a fair knowledge. I won't say an intensive knowledge, an in-depth knowledge, but I would say if you're going to mention a case, you must have a fair knowledge of what this case is all about, right? But when I talk about litigation, I would say anytime that you're approaching the court, no matter what, no matter the stage of the case, you must know A to Z of the case. You must know you must know your case cover to cover. It is very important. The biggest mistake, as I was speaking about a while back, is that most of us in our fraternity just walk into the court think that today it is only a reply which is going to be filed by the respondent, not knowing that it might give me an opportunity that I might be able to bat for some other aspect of the case, which might catapult my case from where it is to where it ought to be, right? So having said that, it is very important not to take things lightly when you're approaching the court, and not to take procedures for granted. There might be an opportunity that would come your way, and you should be ready to knock it off at that particular when that opportunity comes your way, or when you see that or smell that opportunity. Second is, do not ever be complacent. It is largely, I would say, an extension of what I said. Don't take things for granted. So don't be complacent. So just yesterday we were talking about, a colleague of mine, and we were just discussing it within our chamber. And they said that this guy used to be very good, but now he's taking things for granted. He's not very serious about the cases that he takes. He doesn't take his client seriously. He doesn't take even his colleagues very seriously. That is a bad remark for any advocate, from within the people, from his fraternity, or from a client, or from anybody, for that matter. What is important is you should never be complacent. Always be sure. Always be, I would say, sincere at your work. Be very sincere in in your approach when you're taking up a case, when you're dealing with a remedy that you need to offer to your client, when you are dealing with even the back end. Once the client has left, you're left with what is left behind is you and the case, the facts of the case. That is where you need to exercise your utmost diligence. That is when you need to exercise your utmost sincerity. So you cannot be complacent. You cannot be complacent whether with your client, or whether with your case, or whether with your colleagues. So all the C's are important that I mentioned of right now, right? So you need to be always on your tips, doing diligent work, sincere in your approach. That is what I mean. So that mistake you need to avoid, and it is an avoidable mistake. Then never be. So if you never be a slave to procedures. As I said before, you need to follow certain procedures, which are when it comes to drafting, when it comes to a format, which might have to be followed while drafting a particular case. You might have to follow a particular protocol when you're approaching the court. You might have to present your argument in a particular way. But that certainly doesn't mean that you should be a slave to the procedures or the traditional procedures that are there. you can go a bit way out and tread your own path. You should, and for that, as I said before, that is essential, particularly so if you're ready to innovate, and you cannot innovate, as I said before, unless you are courageous. So certainly, as I said, you should not ever be a slave to procedures, but yes, you need to observe the right procedures, but at the same time ready to chart your own course. That is very important if you want to be the best litigator. Now comes the other important and my favorite part, which includes training. So what are the kinds of training that I could actually adopt? So I spoke about the drafting when first and foremost is the drafting skill, of course. So because you cannot present anything unless you have drafted your case very well. Of course, there are arrangements where when it comes to law firms and all, there might be juniors who are drafting and the seniors who are approaching the dais and actually presenting the case. But normally, I'm just talking about beginner here. I'm limiting myself to independent practitioner who is aiming to become the best litigator, right? Or a good litigator for that matter. So in that case, first of all, it all starts with your drafting skills. You need to be good in your drafting skills. You need to ensure that nothing is left out which is important for your case, and you need to know what you've drafted. I have seen mistakes like senior counsel standing in the court and pleading something which is not even there in the draft. You're not allowed to. I mean, anything that you plead has to be born out of your records, right? If your records don't bear it, you cannot actually plead that particular matter. And the opposing counsel comes demolishing the case, saying that sorry, my learned friend doesn't know. Sorry, what the submissions of my learned friend are not born out of the record. So it can be demolished that easily. So therefore, you need to be very good in your drafting skills. If you need to take help from outside, you do that. If you need to take professional help, do that. If you need to take some training or take some additional courses, as I think LawSeco also offers, take those courses and optimize your drafting skills. That is what I will say. Second, do a lot of reading. I mean, I've heard lots of speakers, coaches, life coaches, some even law coaches, advising people no need to read newspapers. It is a myth. It is not necessary. But I would say read a lot so that you have a good understanding about the language. Do you know that the language of the court? I believe most of us know that the language of the High Court and the Supreme Court is English, right? So I would say that you need to read a lot to master this language. You must master. I won't say that you need to be the best, but yes, you need to be at least the average is what I would recommend, right? So read a lot. And when I say read, then what is it that I should be reading? Of course, since you are a law student or aiming or a legal practitioner or a lawyer or a litigator, certainly you need to read a lot from the three areas that I would recommend, which is one is try to read a lot of editorials, right? Second, you could read some literature that helps a lot in your presentation within the court. And third, of course, the most important are judgments, right? So these three areas you need to actually work upon. Many of us may not be doing it. I myself sometimes feel, guilty that, okay, I'm not reading enough. But then these are three areas that you need to really work on. So I'll just repeat that so that you don't miss it out. Ensure that you read a lot of newspaper editorials. You read some literature, so that you know how, sometimes it helps. The knowledge of literature helps in presenting your cases in a unique way or a different way in the court. And last but not the least, you need to actually, read a lot of judgments. So what is the good part about reading judgments is you would of course know what is the case content, how the case was dealt with by the court, and most important of all, what is the legal language that has been used by both the arguing counsels, the arguments that were given by both sides, and how the judge has come to a particular conclusion. What are his observations? So what is the ratio behind the judgment? What is the obiter dicta that went into it? All of that. So reading is a very important skill, a very important, it's a skill, but I would say it is a part of the training. So eventually, eventually after some time, after you have, been, constant with your reading, then you would actually see that it becomes imbibed in you, it becomes a part of you that, there will be natural flow of words. Your grammar would improve, your diction would improve, your understanding of the language would improve. When I say reading, always sit with a dictionary. I mean, let me remind you that it is important to sit with a dictionary, so that there might be some words which come across which you're not aware of. So you can always look up your dictionary and see, what that particular word means and how it is used in a sentence. Those are very important aspects which you need to master. Then always remember that evolving and, improvising is a constant and continuous process. Even I, in perspective of where I am, I believe that I still have a lot to evolve, I still have a lot to improvise, and this is a continuous process, and I'm keen to learn, and keen to unlearn as well those things which I don't need, to put myself up on the pedestal. um, then I come back to the uh, the conditioning. When I was talking about conditioning, I spoke about the word anxiety, right? Anxiety control. So I would include that in the training as well. That yes, you need to also learn or train yourself to control your anxiety, which is